Please be seated. We'll hear argument in 23-202, the Jane Doe Cases.
May it please the court. Ms. Sandel will present argument for the relator. Relator has reserved 5 minutes for rebuttal.
Mr. Chief Justice, and may it please the court. Multi-district litigation is a very useful tool. Where numerous cases share common questions of fact, it provides an efficient mechanism for pretrial preparation that inures to the benefit of both plaintiffs and defendants. But where cases don't share that linchpin of a common question of fact, transfer of cases to multi-district litigation becomes untethered from its statutory underpinnings and raises the specter of forum shopping. The current case shares no questions of fact in common with the cases in the Salesforce MDL because there is zero overlap here in the plaintiffs, the defendants, the hotel premises, the technology, or even the alleged misconduct. And it's because of all of those differences that the MDL panel here should have remanded this case just like it did in Ray Wellington in 2014.
So if this is going to be more convenient and less costly at all, isn't that something we should encourage? What's the downside?
Well, there's multiple downsides, and I first would just say that under the statutory framework set by the legislature, there is an initial absolute requirement that the MDL panel find common questions of fact before it can even consider efficiency or whether combination and transfer would advance the resolution of the cases.
Well, let's argue that you don't have to have the same defendants in order to have that. I'm not saying that's the case. I'm just saying if that were true, then aren't there common questions here?
There are not, Your Honor. We do not believe there are common questions of fact here at all. As I mentioned, again, we think it's a critical point that there are no overlapping defendants, but it's also important that there are no overlapping hotel premises. There are no overlaps in the technology, and fundamentally, there's not overlap in the alleged misconduct. So to be clear, the Salesforce MDL cases, they all allege that Salesforce had a direct business relationship with Backpage.com, whereby Salesforce is accused of helping Backpage to grow its business of letting traffickers advertise victims on its website. That is very different from the allegations here. In this case, the only allegation against Facebook is that it was the location where this criminal trafficker befriended this plaintiff, exchanged messages with her, and convinced her to meet up in person. That's it. There is zero allegation of Facebook's involvement in the plaintiff's trafficking after that point. There is no allegation that Facebook had a business relationship or venture or anything of that sort with Backpage, or that Texas Pearl, the hotel owner, did. And so that makes the cases very, very different. And because of that, and the fact that there's no overlap in defendants or hotel premises, in short, there's not going to be a deposition in a Salesforce MDL case that is going to elicit any information that would be useful to the plaintiffs or the defendants in this case in resolving the questions of fact here.
What about common practices in the hospitality industry?
We think that is a complete red herring, Your Honor. The hospitality industry as a whole is not going to be on trial in this case.
But aren't there defendants in each case that are part of that industry?
There are. Of course there are defendants. There are hotel defendants in each case, in the Salesforce MDL and in this. But they're not the same hotels companies, owners, and they're not
Well,
even
they
the
weren't
same
in the
premises.
They weren't in the Silica MDL either, right?
If you're referring to the In Re Silica MDL decision that's cited by the other side, they weren't. And respectfully, we think that case was decided wrongly by the MDL panel. That's, I think, probably the only case that I've been able to find with the MDL panel creating an MDL where there were different defendants involved. And if you look at that case, the recitation by the majority there was a dissent, but the recitation by the majority lists a number of things in terms of why they are finding relatedness, many of which are just flat wrong. For example, common issues of law are cited in that case, and we know that those do not meet the statutory standard. The plain language tells us that we're
But
limited
it
to
could
common.
be relevant to the efficiency criteria if there are common questions of fact, right? If there are
Sure.
also questions of law.
Sure, common questions of law could be relevant, although we don't think dispositive entirely on the efficiency question. And again, our point is that you must cross through the threshold gate of common questions of fact. And this is a point that I want to also drive home in terms of how the federal MDL has handled this.
Let me, before you get to that, and maybe the federal cases shed light on this, but what constitutes a question of fact? Is it something that a jury has to find, or can it be like an intermediate fact that would then lead you to other facts that would be what the jury is deciding between?
It's a great question, and we think really a crux of something the court has to focus on in deciding this case. We think it's an easy one. So questions of fact in a case are those things that must be decided in order for the plaintiff to prevail on her claims or the defendant to prevail on their defenses. And so I would point you to a couple of cases in that regard. And because this court has never written on MDL, on the MDL standard and what common question of fact means there, that is a topic that's been written on quite a bit in the class action context. I want to be very clear that this is not a class action case. It's not a class action certification case. As I'm sure you all know, those standards are much different, much more robust than in an MDL. So I don't want to give the impression that I am all equating those. However, if you're looking for guidance on what is a common question of fact, that is a small slice of the class action certification jurisprudence. And you can find there, both from this court in In Re Transcontinental Realty from 2000, a discussion of how common questions of fact have to be the things that the case is going to turn on. So we don't think that that requires, in the MDL context, like it requires in the class action context, a really robust penetration into the merits of those claims. But it does require that a court look at the nature of the claims, what's being asserted, and say, okay, what are the things that are going to have to be decided here?
So under this statute, the anti-trafficking statute, presumably the plaintiff would have to secure a finding, and it may not be contested, but would have to secure a finding that she was trafficked. And I think their argument is she has alleged that the perpetrator achieved this trafficking on Backpage. And that's, I think, their argument for why this should be tagged and considered together with other cases that implicate Backpage, like the Salesforce case.
So we disagree. To the extent that is the argument, we disagree completely. As Your Honor well knows, Backpage is not a defendant here, but I take your question to be, well, what if Backpage's conduct is something that has to be examined for purposes of establishing the trafficking element of 98.002? First, I would say, I'm not sure that element is going to be disputed in this case. This particular trafficker has pled guilty to trafficking. I mean, this is an abhorrent human being who is serving 40 years in federal prison for what he did. And so this case is not going to revolve around that. It is going to revolve around whether Facebook or Texas Pearl has any responsibility or liability for what happened to the plaintiff. Our position is, of course, that it does not, but undisputed issues are not fact questions in cases.
Was that in the papers that were before the MDL panel that particular element was not disputed?
Your Honor, candidly, it was not.
Well, then how can we say they abused their discretion?
Well, let me give you some other reasons why we think that even if it were disputed, the conduct
I
of
mean,
that
I've
page-
served on the MDL panel, so, we get whatever comes to us on that panel, and if the parties are not saying, well, this is an undisputed issue, so it shouldn't count, it seems a little unfair to say to those judges, well, you abused your discretion because you didn't know that the parties weren't going to dispute that.
Your Honor, I think at the MDL panel level, the issue of Backpage wasn't really raised by the other side in that briefing. That is sort of a new thing that they have brought up in the briefing to this court.
So should we limit both sides to whatever was before the MDL panel?
Well, I think on the issue of relatedness, you're operating on a de novo standard. I think on the issue of the efficiencies, that probably is an abuse of discretion where you defer to the findings of the MDL panel. But whether there is relatedness, that is, a question of law that you have to wrestle with, and that, frankly, the jurisprudence of this state really needs pronouncement from this court on.
There was a time when stereotypically defendants wanted to be in the MDL. If for no other reason than it caused delays, and again, stereotypically, the accusations were. But here's the opposite. The defendant does not want in the MDL, and the plaintiff wants it in the MDL, and I'm trying to figure out why. And so I guess the proper way to ask that question is, assume you're right that this was error. What was the harm?
Absolutely, and I think this goes to Justice Lehrman's question at the outset. Really, let me give you an example of the harm here. And it does tie into the fact that you can't avoid the fact that there's no relationship between the two. So the absence of common fact questions is part of what makes being in the MDL inefficient. But as a practical matter, let me give you an example. This court's rules for multi-district litigation require, and the MDL court here has adhered to that requirement, that at the outset, one of the things the MDL pretrial court do is to set a case management order. And there's a litany of things that are to be thought out in the beginning. And one of them is the designation or appointment of liaison counsel, right? So you end up in MDLs with a single attorney who gets designated to speak and represent in decisions that will affect the entire group of defendants for them. So that's a real issue. If your case doesn't belong in the MDL because it doesn't meet that threshold common factual question, one of the downsides, a big downside, is that you lose the ability for your lawyer to speak and speak specifically to nuanced things that may be different for you than from the others. And so this actually happened, and this is outside the record admittedly, but in this case, shortly after it was transferred, there was a communication by the plaintiff's counsel saying, who is the liaison counsel as required by the case management order for the technology defendants? Now, we strongly dispute that there's a group of technology defendants. As I mentioned, the allegations against Facebook here are very, very different from those against Salesforce. But that is one example of the serious problems that can arise if you've got cases that bear no factual connection landing in an MDL.
So does a pretrial court not have discretion to appoint more than one liaison counsel?
Sure, but it's very difficult to argue to a pretrial court that has already decided, wrongly we think, that these cases are related, that you should get your own counsel. And we don't think it would be fair to put us to that risk, particularly here where there are no common fact questions.
So you don't disagree that if there was a reason that a party needed to hire their own counsel for blank, that that's a possibility, you just don't think that you should be forced to have to do that, right?
I'm sorry, I'm not sure I understand
So,
the
for
question.
example, I'm following up on Justice Busby's question. So it seemed to me that if, that the court could always appoint another attorney to meet whatever gap there is. And you're not disagreeing with that, right? You just don't want to have to be forced to deal with all of that, right?
I don't want to have to take the risk that the pretrial court might decline
that's
to
fine.
do so, and that I might be forced to have an attorney representing Salesforce. My client might be forced to have an attorney representing Salesforce to carry its position on things like protective orders, or what the schedule for preparation of cases should be, or how many hours should be permitted in a deposition, things like that. And that's not the only downside to this case being in the MDL here. I mean, there has been activity in this case in terms of discovery. I mean, Facebook has already answered the maximum amount of interrogatories it is permitted to have, or that are permitted to be served upon it in this case. And if you move into the MDL, you now are under a case management order that may say, and does say, different things about discovery. There's master discovery. So now I, as the lawyer, have to sit and compare the state of discovery that has already occurred with the master discovery plan, figure out, has everything been covered? Are there new things I need to ask because we have also issued discovery to the plaintiff prior to transfer to the MDL. And I have to sort all of that out. And if there's more than I need on behalf of my client that's not covered by that master discovery that was decided upon before I got to have any voice in the room, I have to go back and petition the court. And those are all costs that my client shouldn't have to incur. I see that my time has expired.
Any other questions? Thank you, Ms. Sandel. We'll hear from the real party.
May it please the court, Mr. Simons will present argument for the real party in a case.
Mr. Chief Justice, and may it please the court, this MDL arises from claims brought by sex trafficking victims against the hotels and technology companies that facilitated their sex trafficking.
What is your argument in response to this idea that there's no common witnesses, there's no common defendant, and so it just doesn't make sense to put it all together for pretrial purposes?
Yes, I think that there are at least two common questions of fact that will be presented in this MDL. First is the presence of a common sex trafficker in Backpage, and second is the standards applicable in the hospitality industry. In this case, and in every other case in the MDL, every plaintiff was trafficked by the same sex trafficker, Backpage. Facebook has stated that this case does not belong in the MDL because there is no common trafficker.
You say that the same sex trafficker Backpage as a perpetrator of the crime, and so you're linking Backpage through the criminal defendant to this case? Or
Yes.
is the criminal defendant individual trafficker? Is the individual trafficker the same trafficker present in some of the other cases?
I do not believe that the same individual trafficker is present in multiple cases. There is an individual trafficker who is criminally liable, but Backpage's conduct also constitutes sex trafficking under the law, and this is something that came up in the federal context and was recognized in the case GG v. Salesforce 76 F 4th 544, a Seventh Circuit case where the court indicated that even though each person has an individual sex trafficker who is the person that controlled them and sold them, Backpage itself engaged in conduct that constitutes sex trafficking under the law. And therefore,
And if they're implicated in this individual MD, in this case, why aren't they a defendant in this case?
I think as a practical matter, they're not a defendant because the company has been seized by the Department of Justice. But even though they are not a party, their status as a party or non-party should not be dispositive of the question of whether there's a common question of fact with respect to them. Because in every case, regardless of whether they're a party, Backpage is a common actor, and its actions affected every plaintiff in this case.
Isn't it sort of public record almost what Backpage did? And it seems that the question here is, what was the participation in the venture, if any, by these defendants? And that seems to me to be a different question, because you're asking about two different entities' knowledge and participation, and you know, what were they up to? And these are, you're asking that about one party versus asking about another party. Where's the commonality?
I think you're right that the question of participation and knowledge with respect to Backpage is a different question than participation with respect to Facebook or Salesforce, so it's not the same. The commonality is, as Justice Bland suggested, is that in this case, under Chapter 98, in order to bring a claim at all, a plaintiff has to establish that they're a victim of trafficking. In essence, only a trafficked person has standing to bring such a claim. And so establishing that Backpage was a trafficker establishes that the plaintiff was a proper plaintiff under the statute. So that goes to a different element, which is essentially the plaintiff's status as a trafficking victim, than the participation and knowledge questions which you're mentioning,
And
Judge.
is your position that even if they're not challenging that status, that remains a common question of fact that justifies putting the cases together?
If there had been a stipulation in the record indicating that Facebook was stipulating that plaintiff was trafficked, I think that would be a different situation. But as of right now, all I have is essentially a representation that it probably will not be challenged, and I don't think that I can rely on that. But if it were truly undisputed and it were stipulated that the plaintiff was a trafficking victim, I agree that that would be a different situation.
Don't we need to look at what was before the MDL panel on that question? I mean,
Yes.
what's this, so if we're reviewing a decision of the MDL panel, we need to know what the standard of review is, and we need to know what the scope of review is. So what's the scope of review that we look at to decide whether the MDL panel applied? We'll get to the question in a second about what the standard of review is and whether there's some de novo and some abuse of discretion. But what universe of things do we look at? Only the things that were before the MDL panel, or can they add to that on appeal?
Yes, it makes sense to me that in terms of the record, it would only be what was in front of the MDL panel.
And can you tell me what was in front of the MDL panel on that question that we were just discussing about what the element of whether the plaintiff was a trafficking victim, whether that was disputed or not?
I do not think an argument was presented in the briefing regarding the trafficking conduct of Backpage, but the MDL panel did have the pleading in the record in front of it, and the pleading did indicate that Backpage was charging fees to broker sex on its website, and that the plaintiff was sold through that website. So the MDL panel had information in front of it about Backpage's conduct with respect to this case.
But would it be necessary to prevail under the statute to secure a finding about Backpage's status as opposed to just simply a finding that the plaintiff in this case was trafficked and the trafficking was facilitated by these two defendants? You don't really need any finding with respect to Backpage to secure those findings, do you?
You need a finding that the plaintiff was trafficked, and at least one way that finding could be proven would be to show that Backpage engaged in conduct that constitutes trafficking under the penal code against the plaintiff. It's possible that that could be proven in a different way, but the plaintiff has the right to prove her case in the way that she wishes, and if she wishes to prove that she was trafficked by establishing that Backpage engaged in trafficking conduct against her, it seems that she should be allowed to do so.
Could it be the case that there are common questions of fact, but it's nevertheless an abuse of discretion to refer the case to the MDL because the questions that are common are just too slight or too tangential or otherwise not likely to be essential to the litigation, and so even though technically there might be a common question of fact, it's nevertheless inappropriate to combine the cases?
Certainly, I think those types of considerations could potentially come into play under the second prong. A court could determine that there is a common question of fact, and therefore the first prong is satisfied, but then a court or the MDL panel could properly determine that because of the circumstances of the case, it would not be efficient to have it in the MDL. So I think that's possible. However, the MDL panel has indicated that transfer to an MDL court does not depend on their determination of what will be, for example, the most important issue in the case. And the MDL panel has indicated that even if an issue is relatively tangential, it can still constitute a common question of fact that can support transfer.
Even if we agree with that, do the facts of this case kind of weigh differently on the efficiency determination? Because our court has already addressed the claims in this case and remanded this claim, and the suit was 4 years along before the suggestion was to tag it to the MDL. So quite a lot has been accomplished in this case. Why shouldn't that weigh in on whether it's appropriate to transfer it?
I think that may weigh in an appropriate case. The progression of the case, for example, in cases where MDL situations where one case is very close to trial and others aren't. In this case, unfortunately, I don't believe it is really true that the case is extremely advanced. This case was stayed for a very long time, both in connection with the initial mandamus proceeding before this court that you referred to and in connection with this proceeding. So this is not really a circumstance where one case is so far advanced that inclusion in the MDL will be irrelevant. It's not a situation where, for example, there's no discovery left to occur. And so, although those timeliness concerns I think could be proper in a certain case, I don't think they should be dispositive here.
If we were to decide that the transfer to MDL was an abuse of discretion and legally erroneous under the rule, do you concede there was harm to Facebook? That error was harmful?
If a case is improperly transferred into an MDL and doesn't belong there, I would agree that that would probably be harmful. I think that
If the lower court had refused to transfer to the MDL and you had challenged that decision as being an abuse of discretion or erroneous, what would be the harm to your client?
the harm would be to missing out on the efficiencies associated with the MDL and investigating these common issues that are more appropriately investigated in MDL as opposed to an individual context.
In the discovery process, you mean?
Yes, yes, pretrial, yes.
And yet, all we're talking about here is discovery into whether Backpage was a trafficker in terms of common issues of fact.
Well, on that point, that is one common issue of fact, but I would also like to mention that in addition to the issues about Backpage, the case in the MDL also the original case in the MDL also present common questions of fact regarding the standards applicable in the hospitality industry. Because in every case in the MDL, the plaintiff was exploited at a hotel. So the litigation will require considerations as to what the standard practices and policies were in the hospitality industry.
What does that have to do with Facebook's liability?
it has nothing to do with Facebook's liability, but under the rule, the question under Rule 13 is whether the cases are related. It doesn't require every individual claim to be related. So as long as there is any common question of fact, any related relationship between the cases as a whole, then the relatedness prong is satisfied. So it can be satisfied exclusively on the basis of commonality on the hotel defendants, even if this court determines that there is no commonality with respect to the claim against Facebook as compared to the claim against defendants in the other MDL cases.
I mean, I'm imagining like you have two employment discrimination claims against the same employer. Yeah, well, I mean, one of the facts that's necessary is that this is an employer. Right? They are running a business. I mean, there are some predicate facts that connect these two situations, but the litigation of them is separate situations, separate decisions, entirely unrelated activities. It would be an odd system if you could take a very slight connection of fact that's unlikely to make a difference ultimately in the case and use that to force people to litigate jointly. I mean, my point is what we're really getting at is cases that ought to be litigated jointly, not sort of technical compliance with the common question of fact prong.
I understand.
And why should these cases be litigated jointly, just apart from what the MDL rule says? Why is it good for these cases to be litigated jointly?
Well, as to the efficiency, for example, which seems to go to that question, these cases do present, for example, common questions of law regarding the interpretation of the statute. And it is more efficient and preferable for those questions to be answered once by a single judge than having multiple judges address that same question multiple times. And these cases are within a relatively niche area which involves these sex trafficking claims. It's a little bit different than, for example, a car crash case. And we have seen already in our experience in the MDL that having an experienced judge understanding not only these claims, these sex trafficking claims, which are fairly new under the law and relatively undeveloped, but also understanding the factual patterns that these cases arise in and how these victims get transferred from social media companies to Backpage to hotels. Having a judge understanding those factual patterns has provided efficiency so that we're not having to educate multiple judges or new judges on the nuances of both this sex trafficking law and also the facts in the sex trafficking industry that are implicated here. It's also notable that in this case, there are common attorneys, which the MDL panel has recognized is relevant at least on the plaintiff's side. And in that sense, the plaintiff's attorneys are not required to, again, argue the same issue again and again before multiple courts and can appear once in one court. The MDL panel has expressed concern about subjecting attorneys to conflicting demands in multiple courts, which would be the case if the plaintiff's attorneys were having to litigate multiple cases on the same topic in multiple courts. There are also efficiencies here because of the issues that I mentioned about Backpage and also about the hotel industry. We're expecting that there'll be common expert witnesses about what is the standard practice, what is the essentially industry standard in the hotel industry. Because in this case, there are negligence claims brought against the hotels. And in order to establish that the hotels were negligent, we'll be required to show what an ordinarily prudent hotel operator would have done. So we're expecting that we will have expert witnesses testify, for example, that an ordinarily prudent hotel operator trains their employees on how to recognize the telltale signs of human trafficking. Then in an individual case, if an individual hotel operator was shown to not have followed those standards, for example, to have not trained its employees, that will be probative of a breach. And so those types of questions, those common questions about what happened in the hotel industry and also about what happened with Backpage, we expect there'll be common witnesses and common experts that will address those issues.
If it was medical negligence and you had allegations that one doctor performed a procedure, another doctor performed the same procedure, they both were negligent, you had a common witness, would that be something that would properly be a common question of fact about the standards of the medical profession? So that should be an MDL. Is that the argument that you're making here?
I think it would probably have to be something more, more specific or tailored. In this instance, we're talking about policies in the hotel industry specifically with respect to sex trafficking. Perhaps if it were a case that presented a very nuanced issue about the standard of care as to a particular procedure, that could present a common question of fact, or that would be properly considered. However, that doesn't necessarily mean that the cases would be transferred to an MDL, because in every case, there's always the backstop of the second factor, which is whether the transfer will promote the convenience, efficiency, and justice.
So if the same plaintiff's lawyer and the plaintiff's lawyer hires the same expert witness, and they're both botched gallbladder removals, then it satisfied both the common question of fact and the convenience. Because as I understood you to say, the main convenience is for the plaintiff's lawyers and witnesses.
I do think there is a difference there in that we also this case also does involve these overlapping legal issues that we're looking for identical determinations on, whereas in that instance, with medical malpractice, the standards are relatively well developed, and so those types of common questions would not be presented. Those types of novel questions that we're addressing here would not be presented, so I think there could be a distinction between that circumstance and the case we have here.
Before you conclude, I just want to be sure I understand your position on the standard of review. Do you agree with counsel on the other side that whether there are common questions of fact or not is reviewed as a de novo, as a question of law, but efficiency is reviewed on the second prong is reviewed for abuse of discretion?
My understanding is that the ultimate decision as to whether the transfer was proper is reviewed for abuse of discretion. But yes, the MDL panel has indicated that the question as to whether there is a common question of fact is a question of law. Because both prongs of the transfer analysis are satisfied on these facts, the MDL panel did not clearly abuse its discretion in upholding the transfer of this case into the MDL court. We would ask that this court deny the petition for writ of mandamus. Thank you.
Any other questions? Thank you, Mr. Simons. Ms. Sano, I believe you have 5 minutes.
Thank you, Mr. Chief Justice. First, I don't believe Backpage meets the statutory definition of a trafficker under the allegations in this case. And I would refer the court to Chapter 20A of the Texas Penal Code, which defines trafficking. And the first thing it says is that trafficking defines what I'll colloquially refer to as really the exercise of dominion over a person. There's a litany of different ways that are listed that can occur, harboring someone, things like that. But that's the first step of establishing the trafficking.
That fact issue is not
element.
undisputed?
It's not sorry, I don't
The
think.
fact issue of whether Backpage was a trafficker in this particular plaintiff's case is not undisputed?
I don't think it's going to be disputed that this plaintiff was trafficked. So 98.002, the cause of action asserted against plaintiff, right, is a civil cause of action against individuals for knowingly or intentionally benefiting from participation in a venture to traffic a person. So if you work backward through that statute, Justice Bland is exactly right that trafficking is an element. We believe that under these allegations, the criminal trafficker, the individual trafficker, is the only person or entity under these allegations that meets the standard under 20A, the definition of trafficking. So that, I say all this in response to the point that, well, Backpage is a common trafficker. So even if we were going to dispute the trafficking element, it's not about Backpage being the trafficker.
So it may be disputed whether Backpage was a trafficker here, but that's not a material fact.
Well,
Because it doesn't matter, because what really matters is if they can show that the individual who's serving 40 years in
Right.
prison was a trafficker, then they got Facebook on the hook on that element without regard to whether Backpage was also a trafficker. Is that what you're saying?
they've established trafficking, that element of 98.002. And I think counsel conceded this, that under 20A, there has to be that sort of exercise of dominion element for trafficking. And then there's a whole host of underlying criminal conduct that can add to that exercise of dominion to amount to trafficking. And just, you know, I hate to say just because I don't want that to sound like I'm not giving it, you know, I'm minimizing it, but sexual assault of a child that you have taken dominion over, that is trafficking. So it doesn't require something further than that. And so I just also want to point out, since Backpage is a focus of a lot of the questions here, we believe that even if it were disputed that there were trafficking here, that really what you would be talking about is did different individual traffickers use Backpage as the mechanism, part of the mechanism of their trafficking? And the questions related to that, if there were any questions about Backpage, would be very specific to the individual. So in this case, it would be specific to what was on Backpage. What did this trafficker post on Backpage with respect to this plaintiff? Whereas in the Salesforce cases, there might be questions about what did a different trafficker post in a different ad about a different plaintiff. So we don't think even in that situation there would be common questions of fact. And Justice Blacklock, to your point, you know, even if there were anything about Backpage's conduct that were going to be relevant to the elements against the named defendants here, we think that would be such a tiny slice of the case that it would not justify transfer to the MDL. And that's particularly true when you realize that Backpage is entirely defunct. Its owners and operators have been sentenced to federal prison. We don't believe, and you can look at the transcript from one of the Salesforce proceedings that we've put into the record, that it's really even possible to conduct discovery from Backpage. So we think that is just a bunch of kind of effort to create some smoke here, but that it doesn't really conjure a common fact question, and certainly not one that would justify moving this case into an MDL.
If we were trying to frame the proper level of generality, you're suggesting it needs to be far more specific and far larger a piece of the case, and the other side is saying the opposite. What language would you suggest we use about that so that we're not just resolving this case, but that we're providing guidance for all cases?
Well, to be clear, I mean, I don't think there is a fact question about Backpage in this case. But if what you're asking me is to assume that you find there is one,
Or the hotel thing, or whatever.
How important does it have to be? I think you can probably look to, you know, the federal courts and the kind of question of predominance. And I think what you do, it's weighing the role of that question against the inefficiencies created by the transfer. I think that's really how that would have to work.
I would think that would be in the second prong, but just in terms of the first prong.
Well, I think they're related, though. I mean, I think determining how insignificant is, and again, I don't think there is one here, but if you've got a case where you decide there is a fact question, but it's too insignificant to warrant carrying these cases over, I think that's how that rule has to be set out, that it has to be a balancing of what role does that question play in the overall case, and what will the effect be of moving the case over. And there's a balancing there. Again, I don't think you have to engage in that here. And then I see my time is up. May I make one other point? The only other point I want to make, and I'll keep it brief because my time has expired, but on this whole hotel industry's, this generalized desire to examine policies, this is one hotel owned by a franchisee. And it is about the security that was in place at that hotel, and I would encourage the court to look at how the federal MDL panel has handled and rejected these exact same arguments when asked to make an MDL to cover all sex trafficking claims against hotels.
Any other questions? Thank you, Ms. Sandell. The case is submitted. That concludes the arguments in the cases set for this morning, and the marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.